Welcome to Protecting Your Legacy with Estate Planning.
Hello and welcome to Protecting Your Legacy with Stonewood Law Group. I'm Lisa Mosby, your host. Adam Grant is the founding attorney of Stonewood Law Group in Encino, California. He helps families across Los Angeles, Orange, Riverside, Ventura, and San Bernardino counties build clear, comprehensive plans that protect what matters and avoid probate. In today's episode, we're talking about trust administration and what happens when a trustee is not following the trust's terms or is acting in bad faith, and how families can respond thoughtfully and lawfully. Adam, thanks so much for being with me today.
Thank you for having me.
To start, could you explain what trust administration involves and what a trustee is legally responsible for once they step into this role?
So sometimes they don't know this role is stepping into them, but people can be nominated as trustees, and oftentimes they know they are the trustee of the trust. And when it comes time, the settlers, trustor, grantor who set up that trust have passed, the trust becomes irrevocable. And at which point you're going to consider administering the trust, or not consider, but you have to then administer the trust. Doing so requires collecting all the assets, regular letters to the beneficiaries, a notice to the beneficiaries. They have to then, if they want, respond, object to how the trustee is then positioned or what they intend to do with the estate. But otherwise, the trustee will work with the beneficiaries to ensure that they receive what's provided for under the trust. So like we kind of spoke about before, there is an elevated expectation that they provide these duties faithfully, that they follow the rules of the trust, and if needed, they can consult an attorney or perhaps bring someone on to work the trust with them, a professional fiduciary being one of those options available.
So Adam, let's create a little clarity around this. Under California law, what duties does a trustee owe to the beneficiary, and what does acting in good faith actually require?
So following the terms of the trust largely, but what you want to do as trustee is ensure you're making the distributions that are set out in the trust faithfully, following its terms, and per the code, following whatever requirements or obligations it has set forth there. And so the trust may prescribe that yearly letters are to go out to the beneficiaries until the trust is wound down, and those yearly letters will contain all the assets, what the intended distribution plan is, so that they are apprised. But the trust largely will have the requirements for that professional, and if they're not a professional, for that trustee. And the trustee will have to then follow the terms of the trust. Perhaps that trustee is also a beneficiary, which means they can administer it to themselves, but only up to what is prescribed in the trust, and ensuring that the other beneficiaries get their share as well.
How can beneficiaries tell the difference between a trustee who's overwhelmed or inexperienced and one who may not be acting in accordance with the trust?
Good question. So largely what you want to take a look at is the trust document itself. The trustee, in faithfully executing their duties, will largely follow what the trust says in the California Probate Code by sending out a letter, which gets a 120-day notice, to the beneficiaries of what they intend to do. And that's where they can acknowledge or assess whether that trustee is faithfully executing their duties. What you'll find often in this area of practice is that the trustee is faithfully executing their duties and following the trust, and the beneficiaries are happy, or the trustee is not, in which case the beneficiaries are the ones who have the right to bring a case or claim to court and ensure that a trustee is put in who can faithfully execute those duties, or ensure that the trustee who is in place gets orders from the court to follow expressly.
I get how it's supposed to work, but what are some common warning signs or behaviors that people may look out for that could suggest a trustee may be mishandling assets or withholding information or even failing to follow the terms of the trust?
So you'll feel it, I have to say to families. They'll know right away because the trustee typically reaches out when something happens and there's some movement in the trust. If a year has passed and you know you're the beneficiary of the trust, with that 120-day notice, perhaps it's important to just note that you do get a copy of the trust. So you would then look through it, perhaps you get counsel to look through it with you, and ensure that what you're getting under that trust is what's prescribed, and the trustee is faithfully giving that to you on the prescribed basis of the trust. If that's not the case, again, you'll feel it. You'll know that the trustee is absent. You'll feel their presence not being there, and you'll reach out to them. Perhaps you'll engage counsel to send them a letter and enforce the terms of the trust. So you'll pressure them to follow what's in the trust and what's prescribed by the probate code and do the regular distributions and the trustee letters and everything that comes with it to faithfully execute their duties. And if they don't, you then bring them to court. You can get instructions from court. You can enforce the terms of the trust. You can seek a replacement of the trustee. So depending on the gravity of the trustee's absence, you can consider these various options.
That's a lot, too. They have many options. What rights do beneficiaries have in California to their information, accounting, transparency, and trust administration?
So as a beneficiary, upon the death of the settlor, once it becomes irrevocable, you are entitled by law to a copy of the trust. That typically comes with a 120-day notice. And so what we'll say again is if you don't understand what's in that trust and what's guaranteed to you under that trust, perhaps you consult with a professional or a lawyer or a CPA, and you go to the trustee. They will give you instructions of how they can be reached. Perhaps they're reached through an attorney, and you seek what's due you. If that does not come by way of pressure from your side, then you do have rights at law, in which case you bring a formal claim at probate court. That can take several weeks, several months, but you can get movement and orders that the court will then either put someone in place or force the trustee to faithfully execute his duties.
So, when concerns arise, can you step us through what options are available to address the situation without immediately escalating into full-blown litigation?
So it all depends on the relationship with the trustee. My suggestion is if you have a good relationship, to try to work it out without lawyers, without professionals. Reach out to them, see what their intended plan is, receive their prescribed notices under the trust. And if you do have objections, bring them to the trustee directly. If you can't do that and reconcile whatever outstanding issues are there, maybe you do get a lawyer, or maybe you do just write a letter and say, this is what is prescribed under the trust. And absent getting that interest, I will seek restitution through court.
Makes sense. I always ask for an example so that people can actually have a real world practical application. Can you walk us through a situation where a trustee's action caused problems for a family and how those issues were ultimately resolved?
Yeah, certainly. I have those quite often. One I can speak about now, just because I'm working on it today, is a client who does have a trustee in place. They don't feel comfortable with who that trustee is. And they have a dispute that then doesn't have the right mechanisms to work out. But another example is where I do have a client who's a co-trustee with their brother, and their brother does not cooperate or does not agree. The long course, of course, is to go to court. It's to make sure that as co-trustee, they get equal transparency, equal access to the accounts, and they get their distributions if they're the beneficiaries. But sometimes that brother or that co-trustee does not get along, does not cooperate, and that's where you do need to go to court. Absent some movement by a demand letter or other recourse outside of court, you then take it to the formal channels where a court will look at the trust and then make a decision whether that trustee is faithfully executing his duties.
So, is there a point when it's really necessary for us to go that route, or is it on a case by case basis as to how to proceed if you can't have a discussion and be civil with each other?
So I would say it's very much on a case-by-case basis, depending on that relationship and how much movement you can make absent professionals or the formal court process. Perhaps there are easier ways to have the trust administered. And the whole purpose or proposition of having a trust is that this is a private document set up between yourself. It's confidential. It remains out of the public purview. These are all things that you want to protect. So if you are having an issue with a trustee, you do have recourse, and there is the ability to make sure that you're adequately protected. Your interests in the trust are secured. And if they're not, you first try to work it out with the trustee. And if not, you do have adequate resources or recourse at law.
And for someone reviewing their estate plan right now, how can careful trustee selection and clear trust reduce the risk of these kinds of disputes later on?
So having those discussions early on is really important. And I think setting up the trust correctly is where people can go wrong if they don't spend the time in due diligence. Again, you want to trust your trustee and trust them throughout. So when you're passed, you know that they'll make those right decisions. And if not, have a conversation with the family and perhaps discuss or consider putting another co-trustee in as a backstop so that they can make decisions together and have some input. And it's not all up to this other person, but providing and selecting the right trustee is essential. depending on your trust goals and needs. For larger trusts, it does make a lot of sense, especially when you're looking for objectivity. When the professional fiduciary is in place, you might not need to have family, because a lot of times people will say either I don't trust the family members I do have, or I don't have those family members. They're just not there. And that's where a professional fiduciary, whether private or a bank, is a good consideration. You can work with an attorney, you can bring on a co-trustee. So there's a lot of options, but planning it out at the beginning is really important. And if you do change your mind or lose that trust, with the revocable trust, consider making those changes so that it's always up to date with the trustee you want in place.
So, for my last question, I want you to sum up what we talked about today in the most simple form for our listeners. What are their next steps with this whole process?
Yeah, so with trust administration, you're looking at the settlor, grantor, trustor having passed and now trying to administer the trust. So what does that entail? What are the requirements? What are your duties under the trust? Professional fiduciaries, if there's one in place, working with them to administer the trust, but otherwise making sure you understand how to do that. And if you don't have those resources, reaching out, bringing in the right trustee so that you can work together, have a co-trustee, or have a professional advising the trustee. You then get a better result, you get that objectivity, and you also get the professionalism that comes behind it. But selecting a trust, making sure that you have the right trustee, the right type of trust, and that you understand who that person's going to be faithfully executing their duties under the trust, that is the right person. And always keeping that right person updated in your trust is extremely important. But when it's not, and comes time to trust administration, it can be difficult, and your family may not want to work with the trustee who's in place. So that's where that forethought is really important, working with the family to make sure your beneficiaries are comfortable with the trustee you put in place, whether professional or family or otherwise, and having a continuity plan so that you have that longevity. This is your greatest asset. It's not a car, it's not a home, it's your estate plan. Make sure it's done right, make sure you have the right person in charge, and that your beneficiaries are going to get what you want them to get.
Very well said. Thank you, Adam, for today and for all this information. Thank you for listening to Protecting Your Legacy with the Stonewood Law Group. If you're dealing with trust administration issues or want to make sure that your plan sets clear expectations for trustees, visit stonewoodlaw.com and be sure to leave a review and share this with a friend who might be able to use it today. And come on back for our next episode.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.